Imagine you had a court date in Fairfax and you thought it wasn't a big deal. A traffic ticket, a minor matter you were going to take care of quickly. But that day, something happened. Time got away from you, you had an emergency, you got confused about the date, or simply the fear paralyzed you and you didn't go. And now you're thinking that tomorrow you'll call the court, explain what happened, and they'll surely understand that it's like showing up late to work and telling your boss you were running behind, that you apologize and go on with your day. Think again, because the exact moment your name was called in that courtroom and you weren't there, something very serious already happened on the other side. It is very likely that the judge issued an arrest warrant against you. And that means what started as a traffic ticket or a minor matter turned into something completely different, something that doesn't get resolved with a phone call or good intentions. Today we're going to talk about exactly what happens when you miss a court date in Virginia, what a capias warrant is and why it is much more serious than it seems, what you should do in the next few hours if you are in this situation, what mistakes can make things dramatically worse, and how to present yourself in the right way so the judge sees this in the most favorable light possible for you. Stay until the end because I'm going to give you exactly what to say to the judge, word for word, and how to handle the entire process in the way that protects you most. I'm Pierre Priale, a criminal defense attorney in Northern Virginia, and in over 15 years I have represented many people in exactly this situation. I've seen how a failure to appear that seemed completely minor turned into a serious legal crisis with consequences that change a person's life. And I've seen how, when handled correctly and on time, that same problem is resolved without major consequences, without an arrest, without an additional criminal record, and sometimes even resolving the original matter in the same hearing. The difference between one outcome and the other almost always comes down to what you do in the first few hours after you realize what happened. Let's start by understanding exactly what happens on the court side when someone doesn't show up. Most people assume that if they miss a court date, the court simply reschedules the hearing. And that's it. That it's like missing a doctor's appointment, that they call you, scold you a little, and give you another date. That the system has enough flexibility to understand that real life sometimes interrupts plans. That is not what happens in Virginia. When your case is called in the courtroom and you are not present, the judge has several options in front of him. And in the vast majority of cases, especially if there was no prior communication from your side, the judge issues what in Virginia is called a capias warrant. That is an active arrest warrant issued specifically for your failure to appear, and it enters the system within minutes. What that means in practical terms is that from that moment on, any police officer who stops you for any reason, a routine traffic stop, a document check, any interaction with law enforcement, is going to see that warrant in the system and has the legal obligation to arrest you on the spot. It doesn't matter where you are. It doesn't matter what you were doing. It doesn't matter if the original matter was something completely minor. This happens every day in Northern Virginia. People who have an active capias warrant for an unresolved traffic ticket are arrested weeks or months later during a routine stop, in front of their children, on the way to work, in a supermarket parking lot. The system does not distinguish between a dramatic moment and an ordinary one. The warrant is there and it is executed when it can be. In addition to the arrest warrant, in many cases the court can also revoke any active bail you had, can issue a suspension of your driver's license, and can add an additional charge of contempt of court that is completely independent of the original matter for which you had the appointment. That contempt charge does not replace the original charge. It is added to it. That means if the original matter was a traffic ticket, you now have that plus an active arrest warrant, plus potentially a contempt charge, plus a possible license suspension. All of that because you didn't show up one day. And the longer you go without resolving this, the more the situation compounds and the more complicated the solution becomes. There is something else I want you to understand about how this system works. Virginia is one of the strictest states in the country in terms of compliance with court orders. The judges in Northern Virginia courts, Fairfax, Arlington, Alexandria, Prince William, take failure to appear very seriously. Not because they are people without compassion, but because the integrity of the judicial system depends on people showing up when the court calls them. When someone doesn't, the court responds with concrete legal tools. What you also need to understand is that a contempt of court charge in Virginia can carry its own criminal consequences. We are not talking about an administrative fine. In some cases, it can result in additional jail time, regardless of how the original matter is resolved. That is why the urgency to act is not an exaggeration. It is the reality of the system. Why your brain tells you to hide and why that is the worst mistake. There is something very human that happens when a person realizes they have an arrest warrant against them. The brain goes into avoidance mode. The instinctive response is to hide, to avoid the situation, to not think about it, to wait for it to pass, to tell yourself that maybe if you do nothing, this will resolve itself with time. That instinct, although completely understandable, although completely human, is exactly the opposite of what you should do. And in many cases, it is what turns a manageable problem into a serious legal crisis. Psychologists call this the avoidance response. When we face consequences that generate fear or anxiety, the brain looks for ways to reduce that anxiety in the short term. And avoiding the problem, not thinking about it, not acting, reduces anxiety immediately even if it objectively worsens the situation. The problem is that in the long term, that avoidance multiplies the consequences in very concrete ways. Every day that passes with an active arrest warrant is one more day in which you can be arrested at the worst possible moment. At work, in front of your children, at a moment where that arrest can have devastating consequences beyond the legal matter itself. And there is something else that has a direct impact on how your case gets resolved. When a person with an active arrest warrant presents themselves voluntarily to court with a lawyer, that communicates something very specific to the judge. It communicates that this person had a problem, that they acknowledge their responsibilities before the court, and that they are taking the correct steps to resolve it. Judges see this every day. They know how to distinguish between someone who ran from their responsibilities and someone who had a problem and is facing it. Being arrested weeks or months later on the street communicates something completely different. Even if the original circumstances of the failure to appear are exactly the same, the way you arrive before the judge changes the dynamics of the case significantly. Presenting yourself voluntarily and on time does not erase the problem, but it puts it in a completely different context. And that context matters enormously in how everything ends up being resolved. The most common mistakes that make the situation worse. Before talking about what you should do, I want to talk about what you should not do. Because in these cases, the most costly mistakes are not the dramatic ones. They are decisions that seem reasonable at the moment but that enormously complicate the situation. The first mistake is calling the court clerk yourself to explain what happened. This is something many people do thinking it is the right thing. They think that if they explain their reasons, the court will understand and resolve the situation. What actually happens is that the call is recorded, and anything you say can be interpreted in ways you don't anticipate. For example, if you say, "I couldn't get transportation that day," that can be interpreted as meaning you knew about the appointment and decided not to go because of a problem you could have resolved another way. If you say, "I forgot," that is basically an admission of negligence before the court. The court clerk is not your lawyer. She is not going to give you legal advice, and she has no interest in helping you present your situation in the most favorable way. The second mistake is going to court alone without having spoken with a lawyer first. There are people who think that if they show up on their own, in good faith, the judge will appreciate that and be lenient with them. And while voluntary appearance is valued, going without representation means you don't know exactly how the judge is going to handle the situation, what questions he is going to ask you, what you should and should not say, and how to also handle the original matter that is going to be on the table in that same hearing. In a situation where there is an active arrest warrant and potentially a contempt charge, going without a lawyer is an unnecessary risk that can result in consequences you could have avoided. The third mistake is ignoring the matter because the original case seemed minor. This is perhaps the most common mistake. The person thinks that since the original ticket was something small, the court isn't going to take the issue too seriously. But the system doesn't work that way. The contempt charge and the capias warrant are independent of the original matter. It doesn't matter if what originally brought you to court was a minor traffic infraction. The failure to appear has its own consequences that can be more serious than the original matter. The fourth mistake is talking about the case on social media or with people outside your most immediate circle of trust. In the age of social media, this is more relevant than ever. Anything you post, any comment you make publicly about your legal situation can reach the prosecutor or the court in ways you don't anticipate. This seems obvious, but it is a mistake we see with surprising frequency. And the fifth mistake is assuming the problem has already expired or that it was erased from the system over time. Capias warrants in Virginia do not expire automatically. They do not disappear with time. They remain active in the system until they are formally addressed before the court. We have seen cases of people who thought an arrest warrant from several years ago no longer existed and who were arrested because the system was still showing it as active. What you should do in the next few hours, if you are watching this video and you just realized you missed a court date, this is exactly what you should do. The first thing is to not panic, but also not to wait. Time in these cases is not your friend. Every hour that passes is one more hour that an arrest warrant is active in the system. You don't have to resolve everything in the next 30 minutes, but you do need to start taking action today. The second thing is to quickly write down all the relevant information you have about the case. The date you were supposed to appear, the case number if you have it, the specific court where you had the hearing, the matter for which you were summoned, and any documentable reason that explains why you could not appear. If you have documentation of that reason, a medical note, an emergency record, anything that supports your absence, keep it. The third thing is to not talk about the matter with anyone other than your lawyer. Not with family, not with friends, not on any digital forum. We already explained why this matters, but it is worth repeating. And the fourth thing, the most important, is to contact a lawyer with experience in Virginia courts as soon as possible. A lawyer can communicate with the court in the correct way, can prepare your voluntary appearance in a way that minimizes the consequences, and can be with you in the courtroom so the process is handled correctly from the very beginning. What a lawyer can do that you cannot do alone. There are very concrete things that change when you have legal representation in a failure to appear situation. And I want to be specific about this because many people underestimate what a lawyer can do in this context. The first is that the lawyer can contact the court before you appear to communicate that you are going to voluntarily present yourself and when. That, in many cases, completely changes the dynamic. The judge knows you are not someone fleeing their responsibilities, but someone who had a problem and is taking the correct steps to resolve it. That prior communication makes a real difference in how the court receives you. The second is that the lawyer knows exactly what arguments work before which judges and in which courts. The Northern Virginia courts have their own dynamics and their own institutional cultures. The Fairfax court is not the same as the Arlington court, which is not the same as Alexandria or Prince William. A lawyer who knows those courts and who has stood before those judges knows how to present your situation in the most favorable way for that specific context. That is not a minor detail. It is a real and concrete advantage. The third is that the lawyer can handle both the failure to appear charge and the original matter in the same hearing when possible. Many times both issues can be resolved at the same time, which saves you time, money, and the stress of having to return to court multiple times for different hearings. The fourth is that the lawyer can explore options for reducing or eliminating charges that you simply would not know exist if you go alone. Depending on the circumstances of your case, your prior history, and the original matter, there may be options available that a lawyer with experience in those courts knows and can request. And the fifth is that the lawyer acts as a buffer between you and the process at an emotionally very charged moment. When you are in that courtroom with an active arrest warrant, with the stress of the situation, with the judge in front of you, it is very easy to say something incorrect, to react in a way that doesn't help you, or simply to not communicate your situation well. The lawyer handles that communication for you in a professional and strategic way, while you stay focused on following his guidance. What to say to the judge when you appear? I want to give you the exact words, because I believe having that clarity is important for reducing the level of anxiety this situation produces. When you voluntarily appear with your lawyer before the judge to answer for a failure to appear, your lawyer is going to handle most of the communication. But if the judge speaks to you directly, what you need to convey is respect, willingness, and responsibility. The phrase we use in these situations, and that has worked consistently in Northern Virginia courts, is something like this. Your Honor, I'm voluntarily presenting myself with my attorney to answer for this failure to appear and to resolve the underlying matter today. That phrase communicates several things at the same time. That you are not running, that you have legal representation, that you respect the authority of the court, and that you are willing to resolve everything at once. Those are exactly the messages a judge wants to receive in this situation. What you should never say to the judge, neither before nor during the hearing, is anything that sounds like a light excuse or a lack of seriousness before the process. I forgot, I was very busy, I didn't understand the date. Said like that without any context or supporting documentation are phrases that can be interpreted as carelessness or disrespect toward the court. If there was a legitimate and documentable reason for your absence, that information has to be presented in the correct way and with the appropriate support. Your lawyer knows how to do that. And if there is no particularly solid reason, your lawyer also knows how to focus the presentation on your current willingness to resolve the matter, which in many cases is equally effective. The specific consequences you need to know about. I want to be very clear about the full range of consequences a failure to appear can have in Virginia because I believe many people underestimate them, and that underestimation is part of why they wait too long to act. The first consequence is the capias warrant we already mentioned. An active arrest warrant that stays in the system indefinitely. It does not disappear with time. It does not expire. It is there until it is formally addressed before the court. The second consequence is the additional contempt of court charge. In Virginia, this charge is serious. It can result in significant fines and in some cases in jail time. And it is a completely separate charge from the original matter, with its own legal process and its own possible consequences. The third consequence is the suspension of the driver's license. If the original matter had to do with a traffic infraction, the failure to appear can result in the automatic suspension of your license by the Virginia DMV. And here is something many people don't know. Driving with a suspended license in Virginia is not simply another traffic infraction. It is in itself a Class 1 criminal charge, the highest misdemeanor category, with everything that implies in terms of criminal record, fines, and possible jail time. The fourth consequence is the impact on your criminal record. An active arrest warrant and a contempt charge are not simply administrative matters. They appear in records in ways that can affect job applications, housing rental processes, credit applications, and many other areas of your life where background checks are conducted. And the fifth consequence, especially critical for immigrant communities in the DMV, is the immigration impact. An active arrest warrant or an additional criminal charge can have devastating consequences in a residency process, in a citizenship application, in the renewal of an immigration status, or in any proceeding where a person's legal history is verified. What started as an unresolved traffic ticket can turn into a serious immigration obstacle if it is not handled correctly and with the urgency it requires. Why this is especially important in Northern Virginia. Northern Virginia has specific characteristics that make everything we just talked about especially relevant here. First, Northern Virginia is one of the areas with the greatest police presence and the most sophisticated background verification systems in the country. The police agencies of Fairfax, Arlington, Alexandria, Prince William, and the other jurisdictions in the region have integrated systems that share information in real time. A capias warrant issued in Fairfax Court can be seen by an officer in Arlington within minutes. Second, the DMV area has one of the largest and most diverse immigrant communities in the entire country. And as we already mentioned, the consequences of an arrest warrant or an additional criminal charge for people in immigration processes are particularly serious in the current environment. We have seen situations where a matter that seemed completely minor in the criminal justice system became a determining factor in an immigration process. Third, Virginia, Maryland, and Washington, D.C. are three different jurisdictions that sometimes interconnect in complicated ways. A failure to appear in Virginia can have effects on your record that show up in background checks conducted in Maryland or the district. A lawyer who knows how these three jurisdictions work has a much more complete perspective on the real implications of your situation. Real scenarios of how this gets resolved. I want to share some concrete situations that illustrate how this process works in practice, because I believe seeing real cases helps better understand what is at stake and what it is possible to achieve. The first scenario is someone who acted quickly after a real emergency. A person had a hearing in Arlington court for a traffic infraction. On the day of the hearing, they had a serious family medical emergency that required their presence at the hospital for the entire day. In the crisis of that moment, they didn't have the presence of mind to call the court, and they did not appear. 3 days later, when the family situation stabilized, they contacted our team. By that point, a capias warrant had already been issued. What we did was communicate with the court immediately to inform them that the person was going to voluntarily appear. We gathered medical documentation supporting the family emergency, and we appeared before the judge with all of that context prepared in a clear and structured way. The result was that the judge withdrew the arrest warrant in that same hearing, understood the circumstances of the absence, and the original matter was also resolved in that same hearing with minimal consequences. That result was possible because action was taken quickly, because there was documentation, and because the presentation was done in the correct way. The second scenario is someone who waited too long thinking the problem would disappear on its own. Another person missed a hearing in Fairfax Court for reasons that could have been perfectly explained. But out of fear, not knowing what to do, thinking that maybe with time the matter would be forgotten, they did nothing for 4 months. During that time, they were stopped in a completely routine traffic stop. The officer saw the active capias warrant in the system and arrested them on the spot. That arrest happened in front of their children, who were in the car with them. They were taken in a patrol car, spent the night in jail while bail was being processed, and when they finally appeared before the judge, the circumstances of their presentation were completely different from what they would have been had they voluntarily appeared weeks earlier. The case was ultimately resolved, but with more serious consequences than it would have had with timely action, and with a level of personal and family trauma that was completely avoidable. The third scenario is someone who tried to handle the situation alone without representation. A person called the court clerk directly to explain why they had not been able to appear. In that conversation, with the best of intentions, they said several things that were recorded. Among other things, they mentioned that they had known about the hearing date in advance, but that on that day they had had a transportation problem. That phrase, although completely honest and although the transportation problem was real, was recorded in a way that the prosecutor interpreted as meaning the person had known about the hearing, had decided not to take the necessary steps to appear, and had therefore deliberately ignored a court order. That context made the subsequent appearance before the judge more complicated and the final consequences more serious than they would have been if the situation had been handled through legal representation from the beginning. These three scenarios illustrate something that is fundamental to understand. The same failure to appear situation can have completely different outcomes depending on how quickly action is taken and whether it is taken in the correct way. It is not the problem itself that defines the outcome. It is how it is handled. Before closing, I want to answer the questions we receive most often on this topic. The first question is, if I have a capias warrant, can I be arrested at any moment? Yes. An active capias warrant means that any interaction with law enforcement can result in an immediate arrest. The warrant is in the system and officers have the obligation to execute it when they see it. There is no grace period. There are no exceptions based on the type of situation you find yourself in when you are identified. That is why the urgency to resolve this is not an exaggeration. It is the reality of the system. The second question is, what happens if you missed court because you genuinely didn't receive the notification? That is a valid legal argument, but it has to be presented correctly and with evidence to support it. If you genuinely didn't receive the summons because it was sent to an incorrect address, because there was an error in the service of notification, or because there was some problem with the court's communication process, that is something a lawyer can argue before the judge with the correct support. But it has to be done in the proper way, not simply stated verbally without any backing. The third question is, can I go to court alone to turn myself in without a lawyer? Technically, yes, you can. But the reasons why it is not recommended are very concrete. Without legal representation, you don't know exactly how the judge is going to react, what questions he is going to ask you, what you should and should not say, how to handle the original matter that is also going to be on the table in that same hearing, or what resolution options are available for your specific case. Going alone significantly increases the risk that the situation worsens rather than improves, especially if the judge asks you direct questions and you don't have clarity on what to answer. The fourth question is, how much time do I have before the situation becomes irreversible? There is no fixed deadline after which everything is resolved or everything is lost. But there is something that is absolutely clear. The more time passes, the more complicated the situation becomes, and the more limited the available options. The window in which a lawyer can handle this in the most favorable way closes with time. The evidence that could support your absence becomes harder to obtain. Witnesses lose memory of the facts, and the history of the active warrant in the system grows longer. That is why immediate action is not just a general recommendation. It is specifically the strategy that produces the best possible results in this type of situation. And the fifth question is, if I resolve the failure to appear, does it disappear from my record? That depends on several factors and is something that needs to be evaluated case by case with your lawyer. In some cases, there are options for charge reduction, conditional suspension, or even charge elimination that a lawyer can explore depending on your prior history and the specific circumstances. But first, the active situation has to be resolved before thinking about the long-term record. One step at a time, and the first step is always to act now. We've reached the end and I want to be completely direct with you. If you missed a court date in Northern Virginia, you have a problem that is not going to resolve itself. Not with time, not by ignoring it, not by waiting for something to change. Capious warrants don't expire. Contempt charges don't disappear. And the risk of an arrest at the worst possible moment does not decrease the longer you wait. On the contrary, it increases. But I also want you to hear this clearly. In the vast majority of cases we have handled, when the person acts quickly and with the correct strategy, this situation has a solution. It is not the end of the world. It does not have to turn into a traumatic arrest, a serious criminal record, or an immigration crisis that changes the course of your life. What determines the outcome almost always is not the severity of the original matter. It is how quickly you act and whether you have the right person guiding you through that process. At Right Path Law Group, we have been handling exactly these cases in Northern Virginia courts for over 15 years. We know the procedures, we know the judges, and we know how to present these situations in the most favorable way possible for our clients. We have resolved failure to appear cases that seemed complicated and brought them to resolutions our clients did not think were possible when they first came to us. If you missed a hearing and there is an arrest warrant in your name, don't wait. Don't call the court alone. Don't try to resolve it without guidance. Every hour that passes is one more hour of unnecessary risk. Call us at 703-722-8044 and get your free consultation today. Or visit us at rightpathlawgroup.com. Because the moment when this is resolved most easily, with fewer consequences and with more options available to you, is not next week. It is today.